on to the stage. Oh, I see my avatar's missing. Well, okay, let's fix our avatar right quick. Here we go. We don't seem to have an avatar. Okay, well, that's okay. I am sitting right here trying to go live with you guys. I just got to fix my avatar right quick. I think I know what the problem is right here. I didn't want to use my um, camera today because I'm not really feeling that great. I'm going to try to stay on the whole live. We'll see what happens. I had visited my son this weekend. I got a little bit ill, but that's okay. We're good. We're good. Anyway, so there's no picture of me. I need to fix that. But other than that, we're going to talk about something really interesting today. I don't know if you remember this case, but remember Ronald Anthony Burgos Aviles, who was an officer of the law. Basically, he was a border patrol officer, and he took the life of his girlfriend and her baby, which was his child, all in an attempt to prevent his family from finding out that he had a mistress. So that is what we're going to talk about today. I'm so good to see everybody today. Please come and enjoy yourself. I'm going to turn a little music on while I fix my avatar. See why I'm not showing up. But that is going to be our discussion for today. So here we go. Let me remember this is go live here. Okay. Want me to go live over there? Okay, that's fine. We'll just fix that one. All right. Anyway, that is what we're talking about today. So, with that, let's get a little music going. I'm going to read my content fair use disclosure, and we'll be ready to go. So here we go. Let's get this over here. I'm gonna get a little music playing while I take just a minute to find my avatar, etc. Okay, guys. Sorry about that. Sometimes these things just happen to us. We don't know why, but it just does. So here you go. I'm going to put this over here, and away we go. So just give me about 2 minutes to fix my avatar, and we are ready to go. There we go. Okay, play. Let me get my avatar fixed. There we are. All right, here we are. Here. All right, disclosure ready. So just give me just a moment. Thank you so much, guys.
Red line dreams, we don't slow down. Engine roar when we hit your town. They stars so sharp like a midnight show. Oh gas, no brakes, little no. Gas, no brakes, little no. Drift through life with a fearless tone. Every move custom, every vibe is on. Not just a car, it's a way of life. Precision, passion, cutting like a knife.
I think we're gonna be ready to go. All right. So good to see everybody. Got my avatar fixed. So yes, today we're going to talk about Mr. Burgos Aviles, and I know he was. We watched his trial. We watched every bit of it. We know everything that happened here, and he did have an appeal. And let's just say his appeal did not go his way. His conviction stands. I believe that is the best thing that could have happened. I'm always happy to hear when the right thing happens, and in this case, the right thing did happen. His conviction should have stand. Let's give it an applause. There you go. Yes, they were right on that. All right, now. So we're going to go back over here. I'm going to show a little bit of something just to kind of refresh everybody's memory about this case and this guy and the horrible pig that he is. Yes, he is a pig. I said it. I'll say it again. So hold on. Let me pull up some YouTube and we will go get on it right now. Now, this is for just a little catch up about what happened to him and the whole situation. So here we go. We're going to use a little bit of Grizzly True Crime's work. She did live stream the whole entire trial. So let's get this over here. Okay, Aviles. We will watch the sentencing really fast. Okay, let's watch the verdict. This is from 2 years ago. And this is going to be full credit to Law and Crime. Here we go. Let's get this ready. All right, one moment. Let me share my screen. I'm going to share my screen so we can catch up on who this is. You'll remember him as soon as you see him. You go, oh, yeah, that piece of shit. That's right. Tried to hide it, tried to act like he just found something over there. Oh, yeah. Here we go. There we go. So, full credit to Law and Crime. Let's listen to this for just a moment.
Going to
All
be.
right.
I'd like to please ask everyone that as difficult as this has been for many of you, I'd like for you all to please refrain from outbursts
Hey there,
of any sort.
Cinderella. So good to see you. Hope you're
I
doing
know
okay
that it's
today.
a very
Yeah, you
emotionally
remember
charged
him?
situation, and I understand it. I can never place my shoes in yours, but please respect the process
Okay.
and the outcome.
Let me just go ahead and give you a trigger warning. This is a trigger
Members
warning,
of the
folks.
jury, did you select the presiding juror? Please stand. Madam presiding juror, did
I'll do
the
my best not to
jury
cry.
of your
Sorry,
peers,
guys.
12 of you, did you deliberate in accordance with my instructions?
Yes, Your Honor.
Was a unanimous verdict reached? Was a unanimous verdict reached?
Oh, you don't. Okay, Cinderella.
Was the verdict forms filled out in accordance with my instructions?
Yes, Your Honor.
Did you sign them?
Yes, Your Honor.
Did your signature reflect the decision, the unanimous decision of this jury?
Yes, Your Honor.
Thank you. Please hand the verdict form to the bailiff. Thank you for your service. In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal act of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Answers to special issue number 2.
Hey there, Daphne. Sounds
Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances.
Okay, so for Cinderella was not familiar, and Daphne Silence is not familiar either with this case. So I'm going to tell you what this case is about. It's very, very horrible. This guy right here was a Border Patrol agent, and he had a mistress on the side, and he's a married man with children and all of that. Well, when his girlfriend told him that she was pregnant, of course he started the get an abortion. She, no, I'm not doing that, right? So she has the child, and he's telling her the whole time, well, I don't want nothing to do with this. I don't want to be involved. All of those kind of things. Well, then it comes down to she's going to go, yeah, now you remember, she's going to go get child support, right? And rightfully so. So before she could do that, he takes her life and takes the life of the baby while on duty. He's on duty. And then he goes over there and acts like he just finds this random person and their baby deceased out there at the border, thinking he's going to get away with this. Thank God he did not. So let's go ahead. We're going to go ahead and read our fair use disclaimer right now, because we are using other people's work, because I was not live streaming at the time when this happened. So for fair use, this is our fair use disclosure for Little Red Zero in analysis of true crime appeals, post-conviction filings, and matters of public record for the purpose of commentary, criticism, education, and public interest reporting. Portions of court documents, transcripts, filings, media reports, or other copyrighted materials may be referenced under the fair use doctrine as outlined in USC 107. All materials are used transformatively to provide legal context, analysis, and discussion. No content is presented as legal advice, and all rights to original materials remain with their respective owners. Individuals discussed in this channel are presumed innocent unless and until proven guilty in a court of law. So there is our fair use disclosure. Now we can move on with this. We're going to go ahead and let this play. Hang on just a second.
Is to warrant that a sentence of
Very
life
sad.
imprisonment without parole rather than a death sentence be imposed? Answer, yes. Signed by the foreperson of the jury. Verdict on punishment as to count number 2, special issue number 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would
I can
commit
see the
criminal
chat. You're
acts
good,
of violence
Desmond.
that
I
would
can see
constitute
you.
a continuing threat to society. Answer, yes. Signed by the foreperson of the jury. As to special issue number 2, whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of this jury. Thank you. Ma'am, you may be seated.
Okay. Now, so that is what happened in
Members
trial.
of the jury,
That is the sentence that he received.
you heard me
So just a second now.
read your.
So that happens. And then after that, this guy goes out, and of course he's going to file an appeal. You know, he's going to file an appeal, and it's going to go through all the proper process, and it's going to get to the Supreme Court. Now, the next thing we're going to do is we're going to go over the appeal that he has filed, which the opinion has been handed down, which is awesome. They seem to move through the whole court process so much faster than they used to. I mean, on a death sentence, it takes years and years, right? But when you've just gotten life without parole, it moves a little bit faster. This trial was so interesting, and I enjoyed watching every minute of it. I know a lot of my friends that come into my chat now were in the chat with me when we were watching this. I mean, so let's go up here. We're going to play a few little things that I had found that talk about this. So let me pull this up. Whoops. So let me show. Okay, so we're going to go over here to the death penalty info or the jury. This is what we just watched right here was that part. Now we're going to go over here and let me pull this back up. Hang on just a second, guys. Now I want to be able to show you a few more things before we actually read. Let's watch the interrogation really quick. And again, this is from Law and Crime Network right here. All right. So this is from Law and Crime, and this is his interrogation.
Trial wraps up in Laredo,
Thank
Texas,
you, Jesse
for a
Weber.
Border Patrol officer facing the death penalty. Prosecutors accuse him of killing his alleged mistress and young son over child support money. Ronald Burgos Aviles had a child with 28-year-old Griselda Hernandez while married another woman.
Look at that beautiful child.
In March of 2018, Hernandez reportedly served the defendant child support documents at his workplace, and police say that Burgos Aviles arranged an in-person meeting the following month with Hernandez and their nearly 2-year-old son. At that meeting, prosecutors accused the defendant of stabbing them to death, all in an effort to avoid Hernandez child support money, paying that up. This week, several officers testified for the prosecution, detailing Burgos Aviles' at times bizarre behavior at the crime scene and while detained. Photos of injuries on the defendant were shown to the jury as well, along with evidence of his police radio, cell phone, and DNA being present at the murder site. Because the defendant works in law enforcement, defense attorneys challenged witnesses on their statements before and after they realized a fellow officer was the prime suspect. But Friday, words were heard directly from the defendant's own mouth through his police interrogation on the day of the murders.
Can y'all hear that okay, or do I need to turn it up?
To the best of my ability, but as we keep talking about this, pieces are coming in, and I'm telling you. You go to a gruesome crime scene, and you're grabbing shoes, and you're grabbing strollers, and you're not being appropriate about your communications with 940. 940 needs to call it, but that's not your jurisdiction. That's a murder investigation. So that's murder and child right there. Yes. they're gone. And he's like, and you just thinking about yourself, kind of thing, or no.
And they're
Based
gone,
on what we
mister,
know right now,
by your
we want to
hands.
stop what we're doing and turn our attention away from you and go somewhere else. No, I want you guys to do that. No, but that only a rational person can say that. I mean, do you want us to stop what we're doing and go somewhere else? No, I want you guys to do your job. And you want us to let you go? No. You guys are still. No, we can't be. Why am I going to? I don't even. We already know each other. Why can't I take it personally? Your point is saying that he's like, I know.
All right, hang on just a second. I want to make sure we're not getting any kind of all right, it's showing that it showed me on my iPad that my thing is live. Thank God, because you know what I don't want is any kind of a little hit on the the copyright thing. It's every time you turn around, YouTube has really gotten hard about this. Every time you turn around, somebody's either getting a copyright strike, their channel is getting removed. I mean, it's really they've ramped up how they're taking care of this, which is good and bad. I will say that it's good and bad. So let me pull up the appeal over here. Is at the Texas Court of Appeals. I was going to talk about something else today, but then when I saw that this case had already been through and that his conviction was confirmed, I was like, yes, we're going to talk about this one instead. So I'm going to pull this back up. And this is Ronald Anthony Burgos. I wish I could roll my tongue and get that accent, but I really cannot. Aviles. Okay, here we go. Texas courts. So, first thing I'm going to read before we get over to the appeal is we're going to read the actual charge that happened in the courtroom because I think it's kind of interesting because this is what was actually filed with the court system with the jurors with their actual signature of the foreperson and the judge. So here we go. This is the actual charge of the court. And this is members of the jury. Okay. The defendant, Ronald Anthony Burgos Aviles, stands charged by indictment with 2 counts of the offense of capital murder alleged to have been committed in Webb County, Texas, on or about the 9th day of April, 2018. The defendant has pled not guilty. Our law provides that a person commits this offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that the person commits the offense of capital murder if he commits this murder herefore defined as the person intentionally or knowingly causes the death of more than one person during the same criminal transaction. Our law provides that a person commits the offense of capital murder if he commits murder or herefore defined and the person intentionally knowingly causes the death of an individual under the age of 10 years old. So it's loud enough. Oh, thank you so much. Okay, good, Daphne Son. So good to see you today. I really am. Thank you for coming in. A person acts intentionally or with intent with respect to the nature of his conduct or result of his conduct when it is his conscious objectives or desire to engage in the conduct and the cause of the result. A person acts knowingly or with knowledge with respect to the result of his conduct or to the circumstances surrounding his conduct when he is aware that the nature of his conduct or that his conduct is reasonably certain to cause the result of death. Individuals means a human being who is alive. Okay. So you are instructed that you may consider all the relevant evidence concerning the relationship that existed between the deceased and the defendants. If any prior to the alleged killing, the facts or the circumstances surrounding the alleged killing and all of the relevant facts and circumstances showing the condition of the defendant's mind at the time of the alleged killings. Our law provides that the time of the offense, the alleged in the indictment must be some date anterior to the, this is weird, to the presentment of the indictment and not so remote that the prosecution on the offense is barred by limitations. In other words, it has to be within the statute of limitations. So, the phrase on or about means the state is not required to prove the alleged offense happened on an exact date. Our law provides that the time of the offense alleged and the indictment must be some date anterior to the presentment of the indictment and not so remote that, okay, so we talked about that. It mentions this in a couple of different spots. There is no limitation period for the offense of murder and capital murder. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before June the 27th of 2018, which is the date the indictment was filed. So there you go. It's talking about that. So count one of this indictment is, now, if you find from the evidence beyond a reasonable doubt that on or about the 9th day of April 2018, at Webb County, Texas, the defendant, Ronald Anthony Burgos Aviles, did intentionally or knowingly cause the deaths of Dominic Alexander Hernandez and Griselda Hernandez during the same criminal transaction. Trigger warning, folks, trigger warning, I'm sorry. By stabbing Griselda Hernandez multiple times with a sharp object, and by stabbing, okay, this is where I start crying. I'm sorry, guys. Let me get myself together. Oh, okay. By stabbing Dominic Alexander Hernandez in the chest and or slashing Alexander Hernandez's throat with a sharp object. Then you will find that the defendant, Ronald Anthony Burgos Aviles, is guilty of capital murder as charged in the indictment. This is his own flesh and blood that he has done this to, this little baby. This is a baby in a stroller. Just an innocent, look at him. He makes me sick. When I read this, it makes me sick. Unless so unanimously find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will acquit the defendant of murder and say by your verdict not guilty. Count two. Now, if you find from the evidence beyond a reasonable doubt that on or about the 9th day of April 2018, at Webb County, Texas, the defendant, Ronald Anthony Burgos Aviles, did intentionally or knowingly cause the deaths of Dominic Alexander Hernandez, an individual under 10 years of age, by stabbing Dominic Alexander Hernandez in the chest or slashing Alexander Hernandez's throat with a sharp object, then you will find the defendant, Ronald Anthony Burgos Aviles, is guilty of capital murder as charged in the indictment. Unless you so unanimously find a beyond a reasonable doubt that, or if you have a reasonable doubt thereof, you will acquit the defendant of the murder by saying your verdict as not guilty. You have heard evidence that the defendant made an oral and recorded statement on April the 9th during a custodial interrogation conducted at Laredo Police Department by Laredo Police Detective Rick Reyes and Ernest Elizondo. If you find the defendant did make the statement, you may consider the statement against the defendant only if you resolve a preliminary question in favor of the state. An oral record statement by a defendant made as a result of custodial interrogations may be considered only if before the statement but during the recordings. The defendant was, 1, warned that he, A, has the right to remain silent and not make any statements at all, and that any statement he makes may be used against him in this trial. 2, by any statement he makes may be used as evidence against him in court. He has the right to have a lawyer present to advise him before the, during, and after the questioning. If he is unable to employ a lawyer, he has the right to have a lawyer appointed to advise him before, during any questioning, and he has the right to terminate the interview at any time. And the defendant knowingly, intentionally, and voluntarily waived the rights set out in the warnings. Therefore, you may only consider the statements made by the defendant to the detectives on April 9, 2018. If you all first agree that the state has proved beyond a reasonable doubt that before the statement was made, but during the recording, the defendant was given the warnings set out above and knowingly, intelligently, and voluntarily waived the rights set out in the warning. If you do not find that the state has proved these things beyond a reasonable doubt, you must disregard and not consider for any purpose any statement that the defendant may have made. If you do find the state has proved that these things beyond a reasonable doubt, you may consider that the evidence that the defendant made the statement and give their evidence whatever weight you believe is appropriate. You may consider all the facts that are shown by the evidence and should draw natural and reasonable inferences from such facts. You alone have the authority and the duty to determine whether the facts are in this case. In evaluating the evidence, you must totally disregard that you believe is my opinion about any factual matter. Okay, that in evaluating, let's reread that statement because it sounds strange, right? In evaluating the evidence, you must totally disregard what you believe is my opinion. Okay, so don't consider the judge's opinion. It's only what you see as the facts based on what you were told. Okay. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence almost is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt that the defendant's guilt after careful and impartial consideration of all the evidence in this case. In a criminal case, the law permits the defendant to testify in his own behalf, but the same law provides that his failure to testify shall not be considered as a circumstance against him. You will therefore not consider the failure of the defendant to testify as circumstances against him, and you will not in your retirement to consider your verdict allude to, comment on, or in any manner refer to the fact the defendant has not testified. The prosecution has the burden of proving the defendant guilty and must be doing so providing each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all reasonable doubt. It is required that the prosecution prove excludes all reasonable doubt concerning the defendant's guilt. You are further instructed as part of the law in this case that the indictment against the defendant is not evidence in the case, and that the true and sole use of the indictment is to charge the offense and to inform the defendant of the offenses alleged against him. The reading of the indictment to the jury and the statement of the state's case against the defendant cannot be considered as fact or circumstances against the defendant in your deliberations. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for a jury to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any juror, nor consider it themselves in arriving at a verdict. You shall not discuss or consider the punishment, if any, which may be assessed against the defendant in the event that he is found guilty. You may not discuss this case with any court officer or the attorneys or anyone not in the jury. You must not discuss this case unless you are all present and in the jury room. If anyone leaves the jury room, then you must stop your discussions about the case until all are present. Again, that's okay. Remember the statement we just made, and then remember what happened whenever the Murdaugh case happened, okay? Because they were discussing it with that lady. His opinion has not come out yet, but I know he's going to get a new trial. I just know he is based on the fact Becky Hill ruined that. Because all the things in this charge that you're not supposed to be doing, she was discussing that with the jurors, and she had no place to do so. And they're just jurors; they don't really know any better, right? So anyway, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge the offers assigned to you. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Questions and comments on the attorneys do not constitute testimony. It must not be considered as evidence. You must also disregard any statement of the attorneys that's inconsistent with the law contained in this charge. The role of the judge is to preside over the trial and to rule on objections and the admissibility of the evidence, but not to comment on the weight or the credibility of such evidence which is to be given by the jury. Therefore, the jury shall not draw from the conduct or comments of the judge any inference as to the weight or credibility of evidence admitted before them during this trial. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during the deliberations. However, you may not share your notes with other jurors, and you should not permit the other jurors to share their notes with you. You may, however, discuss the contents of your notes with the other jurors. You shall not use your notes as authority to persuade your fellow jurors. If your deliberations give no more and no less weight up to the views of the fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the lawyers. Notes are valuable as a stimulant to your memory. On the other hand, you may make an error in observing, and you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of what the evidence was during the trial. Occasionally, it's almost done. This is the last page of this. Occasionally, during deliberations, a dispute arises and the testimony presented. If this should occur in this case, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcripts. You shall not rely on your notes to resolve the dispute because the notes, if any, are not official transcripts. The dispute must be settled by the official transcripts for the official transcript rather than any juror's notes upon which must base your determination of the facts and ultimately your verdict in this case. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight of the given to the testimony. But you are bound to receive the law from the court which is herein given you and be governed thereby, which is the official charge, which is what we're reading right now. After reading this charge, you shall not be permitted to separate from each other, nor shall you talk with anyone not of your jury. After argument of counsel, you will retire, select one of your members as the foreperson. In his or her duty to persuade, not persuade, because you cannot persuade other jurors. That's against the rules. It is his or her duty to preside over the deliberations and to vote with you, arriving at a unanimous verdict. After you have arrived at the verdict, you may use the forms attached hereto by having your foreperson sign his or her name to the particular blank that conforms to your verdict for each count. But in no event shall be he or she sign more than one of such blanks on such form. So that's the official charge that they were giving at the end of the trial. Now we're going to listen to his statement for just a minute. He's such an arrogant bastard. I'm sorry, I'm going to say some curse words. You know I'm not monetized. It's okay. But he's an arrogant piece of crap. Here we go.
I think if whatever he's
Unbelievable.
that's his personal opinion, so I know for a fact that
He's
being very patient with me, you don't believe me either, so I know you don't like me either. That's not a lie, bro. I mean, I know you guys saying things, I know, and the way I understand, believe me, in a way I understand, but in another way, you gotta understand, like, I feel cornered, man.
Terry, here's the thing. Oftentimes, the first person to discover the body is going to be questioned as a person of interest, right? So why would the defendant put himself in that position?
Jesse, I think it's all ego. He is trying to control that scene. He thinks he can direct the other officers away from himself. Little did he realize they were already focused on him because they did get information right after they got to the scene that the victim basically said she was going to meet someone by his name at the scene. So immediately those officers began to hone in on him. And you saw there the questioning they did. And that information, based on what we've seen at trial, the testimony of officers, was corroborated by cell phone data, and also DNA data is going to be corroborated as well. So I think he made a mistake trying to be there and control the situation. It definitely backfired against him.
Now, Judge, this case is being tried in Texas. It's a horrible crime, but do you think
it is a horrible crime?
Case?
Well, that obviously has two different pathways to answer. First, under Texas's death penalty statute, and every state has their own, he qualifies for the death penalty. There was a child under 10 that was murdered here. There was multiple people that were killed. There were two circumstances that justify the death penalty. But whether and under what circumstances to pursue the death penalty is really a question that is being bandied about in our country. And we've seen that the reduction in the death penalty in many states because of the question of its effectiveness, its unfairness with regard to race. And
now, if you listen to him, what he was saying, it's fine. Okay. Did you listen to what he was saying? And I mean, how they were already on to him? He's over there trying to control the scene because he is a typical, what is he? Sociopath, right? He's got some mental disorders. Classic right there. Classic narcissistic personality right there. But we'll listen a little bit more. I'll pull this other thing up. Hang on, guys.
Gender and socioeconomic status. It's question of whether or not it actually is deterrence. So whether they should, that's another question completely.
It's understandable why they pursue. Just look at the pictures of the victims. I think enough is said right there. We now know when rapper YNW Melly's co-defendant will head to trial.
Hang on. Now we're going to get off of that. Okay. Now we'll go over here and pull this one up right over here.
I want to.
He's going to make listen, he makes a story up as he's sitting there. It's terrible.
You turn around,
He just makes up his nose right there.
So you know where the CP's eyes were parked? Yeah. Possible court? Yeah. All right. Went in. All right. Turn. Did a donut. All right. Came out. The same way I came in, same way I came out. Went to the soccer fields. Saw Larry and Smith. Where? Good. All right, where?
Oh, come on now.
Talk to him. Told him what I was gonna do. And I left. About leaving, that's where the situation happened. I called it out. I put it on the radio. I called out. He showed up with me. When he showed up with me,
Yes.
everything started going wrong. He's asking me all kinds of questions. How long do you think she's been there? Blah, 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 this and that. It looks like it's clean from last night or whatever. All kinds of things are going on. All right, our friends, they turn around for the donut. Yeah, I know what you're right.
It's crazy.
You know where the CP guys were parked? Yeah. Basketball court, yeah.
Everybody already knew.
All right, turn. And the donut. All right. Came out. The same way I came in, same way I came out. Went into the soccer fields. Saw Lara and Smith. Where? Good. All right,
That's pathetic. It's really pathetic.
Told her what I was gonna do.
We could pull this up over here.
About leaving, that's where the situation happened. I called it out. I put it on the radio. I called Lara. He showed up with me. When he showed up with me, everything started going wrong. He's asking me all kinds of questions. How long do you think she's been there? Blah, 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 this and that. It looks like it's clean from last night or whatever. All kinds of things are going on. All right, our friends.
All right. We're going to turn this off. We're going to go back and actually look at his actual appeal. I mean, look at that face. Just look at him. It's a piece of shit. Anyway, here we go. Sorry, guys. I'm going to get rid of that. We're going to quit sharing that screen. We're going to actually share this other screen. So let me share the screen over here and we'll get after it. This is his actual Court of Appeals document right here. All right. We'll share the screen, silly lady. Share the screen. And it is right here. All right. There it is. So we're going to read along here. And we're going to look at this. I'm going to take the stars off because it's not anybody's content. So I can do that. I don't have to cover it. There we go. So I hope that's big enough for you guys to see it so you can follow along with me. I'm going to try to we'll split the screen a little bit over here for that part. And I'm going to read it aloud to you. We're going to talk about it, read it, and there you go. So here we go. Y'all ready? Now, I can see the comments. We're good. So this is the discovery of his appeal. And this is on April the 9th, 2018. Burgos Aviles, a Border Patrol supervisor, was assigned to work from 6 a.m. to 4 p.m. in the area that included Father McNoby Park in Laredo, Texas. At 11:18 a.m., he radioed a call for assistance, saying that he had found an injured woman on a trail. He knew she was more than injured, okay? Border Patrol agent Bradley Dennison arrived at the scene shortly afterwards. He saw that the victim was deceased and was laying in a large pool of blood. He testified that he decided to check the brush and the area by the river to look for a perpetrator or any other victims. Dennison had 18 years experience in tracking individuals and testified that an area in the tall brush appeared that it had been, like pressed down, indicating somebody was there for an extensive period of time. He believed it was likely where the perpetrator had hidden or was waiting in ambush. As he continued to investigate the brush, he found another deceased victim, a young child, a stroller, and a shoe that matched the shoe on the trail next to the first victim. This trigger warning, guys, trigger warning, so sorry. According to the other Border Patrol agents who were there at the scene, Burgos Aviles contaminated the scene and the evidence despite having received training in evidence preservation. See, he was trying to cover his own tracks right there. I know it looks suspicious to all of them. I know it did. Then he goes, for example, Agent Francisco Lara saw that Burgos Aviles picked up the victim's body. Oh, God. On later questions, Burgos admitted to moving the body, but claimed to have done it to see if she was still breathing. Laura also said that Burgos Aviles picked up the shoe found in the brush and put it in the victim's feet and put it by the foot. Wow. Laura and Dennison both testified that Burgos Aviles was leaving prints by walking on the trail and scuffing his feet a few times in the dirt, destroying any prints already there. Burgos Aviles also kicked and moved a rock that had blood splatter and was near the body. That is so intentional. It is intentional. You can see it. Multiple officers from the Laredo Police Department soon arrived, and as all part of the, put these other glasses on, investigation took written statements from the Border Patrol agents that were there. Burgos Aviles was asked the detective for the police department at least 3 times if they had been able to identify the victim. And although cell phones belonging to the victim were later found in Burgos Aviles' truck, so he has the evidence right there in his truck. What a dumbass. He did not notify anyone on the scene that he had them. Of course not. He's trying to hide, that he did this. Laredo Police Sergeant Gilbert Benavides testified that he followed the stroller tracks from the trail to a paved road that went to the parking lot. In the parking lot was a car with a child seat in the back, and believing it could be connected to the victims. Benavides ran the place and learned that the owner was Angelica Hernandez. Benavides went to Angelica's address and, in speaking with her, learned that Angelica's sister, Griselda, had borrowed her car. Angelica told Benavides that Griselda took her son, DAH, they just used the initials because of his age, to the park where she planned to meet her with DAH's father, a Border Patrol agent named Anthony Burgos. Right there, he was told on, right there. He radioed the information to the officer at the crime scene. Burgos Aviles was still on the scene and heard his name. He denied that Griselda was an ex-girlfriend and was not forthcoming when asked his name. Once the officers confirmed that Burgos Aviles' full name and Angelica confirmed that she, the victims, was Griselda and DAH, Laredo police officers detained Burgos Aviles and placed him in a police vehicle to be transported to the station. The video of him in the car shows him appearing to be, oh Lord, this is even worse. Now listen to what he was doing to try to also get rid of evidence. He began to, oh, this is nasty. Damn. So he began to he was licking his fingers and was wiping something off his arms. He was also heard saying, "Los teléfonos," the telephones, which the state argued was him remembering that he left the cell phones in his Border Patrol unit. Griselda's autopsy revealed that she had approximately 27 stab wounds, including to her neck, where both her carotid arteries were severed. She also had I always say this wrong, bear with me, a subcarotid hemorrhage from blunt force trauma to her head. The baby was stabbed in the chest and the neck, also severing his carotid artery. The medical examiner testified that he believed the deaths were intentionally caused because of the number of wounds, as well as the fact that the neck area that was targeted. Burgos Aviles' relationship with Griselda. The murders exposed an extramarital relationship between Burgos Aviles and Griselda. When Griselda became pregnant, Burgos Aviles did not want her to have this baby and told her that he wasn't living in Laredo. He was absent from their lives and did not help to financially support AH. However, around February 2018, when DAH was nearly a year and a half, Griselda learned that Burgos Aviles was not separated from his wife, and he had told her that he lived in Laredo. So he had lied to her about everything from day one, as usual, because, the other woman always gets that lie. Well, I'm going to divorce my wife. I'm going to be leaving my wife. And so these women get into these relationships with these guys thinking that they're going to be the next wife. That's what happens here. Just a total narcissistic piece of crap here. Yes, and please, just know I'm going to have some ugly things to say about him, because anybody that can do this to a baby is a real piece of garbage. Okay, so Griselda learned that Burgos Aviles was not separated from his wife, as he had told her, and that he lived in Laredo. Griselda, a nursing student, was relying on student loans to pay daycare and decided to apply for child support services. Burgos Aviles found out about the child support applications. He was upset, and they argued about it. Only after that did Burgos Aviles ask to meet DAH for the first time. He had never even met this child. So he meets this child just to plan to take his life. That is horrible. Investigations. Griselda's phone and phone used as a toy by DHS were found in Burgos Aviles' Border Patrol truck, and both had blood on them. Blood was also found on the tailgate and on a belt keeper in Burgos Aviles' truck. DNA testing showed that it was extremely probable that the blood was from DAH and Griselda. Surveillance video at the park showed Griselda entering the park on the day of the murders at 9:09 a.m. During this time, data from Burgos Aviles and Griselda's cell phones showed that the phones were at or near the crime scene around 9:30 a.m., the estimated time of the murders. He left the park at 10 a.m. and traveled to the areas of Burgos Aviles' home and then back to the park. So he goes over there, he takes their lives and hides them. Then he drives home and takes a shower, cleans himself back up, and comes back over to work like nothing ever happened. That is a real piece of shit. Just like nothing happened, like they were nothing but trash to him. That's all it was. Well, let me go wash the trash off of me now and just keep on going. In addition to the data from the cell phones, GPS data from the Motorola radio in Burgos Aviles' truck confirmed this movement. A home security video from Burgos Aviles' neighbor's house showed that Burgos Aviles arrived home at 10:27 a.m., not wearing his Border Patrol uniform, and left around 10 minutes later. Surveillance cameras from the local businesses also captured video of Burgos Aviles traveling along the route from the home back to the park at that time. In addition to the evidence about the murders, the state elicited testimony about an incident 15 days before the murders. Once Burgos Aviles learned that Griselda had applied for child support, he asked to meet DAH for the first time. Griselda agreed on March the 25th, 2018. They met at the Winfield Park. Griselda told her sister that while at the park, she went to the car for snacks to give Burgos Aviles time alone with the baby. When she returned, the baby was crying and could not be soothed. She cut their meeting short and took the baby home. I'm not saying his initials because it's going to make me cry. I'm just going to call him the baby, okay? Just bear with me. When she returned, the baby was crying and could not be soothed. She cut their meeting short and took baby home. But he continued to complain and cried when his leg was moved. Griselda's sister, Angelica, is a nurse and examined the baby. She testified that she saw a dot of blood on his thigh and asked Griselda if he had recently gotten any shots. Griselda said he had not. They believed that since they had just been to the park, it was like an insect bite. Oh my God. Now remember this part. Okay, Cinderella, you remember this? This is absolutely horrible what he did. Yes, he injected this poor baby. He hurt this baby. Oh, I hope he's somebody's bitch in prison. I hope he is. I hope he is. Griselda took the baby to the emergency room that afternoon. Griselda told the doctors that the pain started when they were at the park and that the baby was discharged with instructions and medications for an allergic reaction from what they believed was an insect bite. The pain, however, got worse. The baby was no longer able to walk. Griselda took him to urgent care and his pediatrician, all of whom assumed, based on what they had been told, that this injury was an insect bite. The baby could not walk after that day and had been scheduled to see a pediatrician specialist on April the 11th, 2 days after he was killed. Angelica testified that after the murders, she believed that the baby's leg injury was caused not by an insect bite, but by prior attempts to kill him. She contacted Corrine Stern, the medical examiner, who agreed to examine the baby's leg, although autopsies had already been done. Stern testified that she disagreed with the insect bite diagnosis and believed that the baby was injected with something because only the tissue deep into the muscle was necrotic, while if it were an insect bite, the skin would be also necrotic. Stern called the hospital to ask for the blood samples that they had taken, but they no longer had them. She took a tissue sample, but they did not test it because they did not know what to test it for. That's right, this piece of shit injected that baby with something and did not tell anybody what it was. And from what I understand, he's never told anybody what it was. He denies it, even though we now know it's true. Among Burgos Aviles' belongings, they found during a search what was a bag with hypodermic needles with a syringe. To explain what these items, Burgos Aviles introduced into evidence medical records that showed that his doctor had prescribed testosterone by injection. Okay. The jury convicted Burgos Aviles of 2 counts of capital murder, and he was sentenced to life imprisonment without the possibility of parole. On appeal, Burgos Aviles argues that the trial court committed 5 errors: discharging his initial second chair counsel, denying his motion to change venues, admitting the evidence to an extraneous offense, and denying his motion for mistrial, and admitting the location evidence obtained from his and Griselda's cell phones. He's trying anything he can. The trial court did not err in discharging Burgos Aviles as second chair attorney and appointing a new one. Appointment and discharge of an attorney. In his first issue, Burgos Aviles argues that the trial court erred in discharging one of his attorneys. Shortly after Burgos Aviles was arrested, the magistrate appointed attorney Silverio Martinez to represent him. However, because Martinez did not have the qualifications to be appointed in a case which the state seeks the death penalty, the trial court appointed Eduardo Pena. So, You have to have certain qualifications to do a death penalty case, and his first attorney did not have those. So then it was the trial court appointed Eduardo Pena, who did have such qualifications, as lead counsel under the Texas Code of Criminal Procedures. After Martinez applied for and was approved for second chair appointment in the death penalty cases, the trial court appointed him as second chair. Approximately 9 months later, Pena filed a motion asking the trial court to remove Martinez and appoint another attorney instead. The motion and its attachments detailed increasing animosity between the attorneys. Pena alleged the following. Okay, so then his attorneys start fighting amongst themselves. That's really sad. Approximately 9 months later, Pena filed this motion. Martinez took actions such as filing discovery motions and setting hearings without consulting Pena or obtaining his approval. Martinez caused friction between Pena and Burgos Aviles by giving Burgos Aviles incorrect information and unrealistic expectations. For example, Martinez allegedly told Burgos Aviles that he would qualify for bond. No, you do not qualify for bond in this kind of a situation. Martinez gave a conflicting assessment of the evidence to Burgos Aviles and his family, making it difficult for Pena to work with them on mitigation evidence. For example, Martinez told Burgos Aviles' father that they would be able to refute cell phone location evidence that showed that Burgos Aviles had possession of Griselda's cell phones for 40 minutes before he reported finding her, and that Pena had already given up on defending Burgos Aviles. Pena and Martinez did not agree on the strategy. According to Pena, Martinez wanted to pursue unsubstantiated theories of innocence, and Pena wanted to focus on mitigating evidence, although he recognized continuing duty to investigate evidence of guilt and innocence. Despite the meetings and the emails about the importance of the unified defense strategy, Martinez continued to explore what Pena considered to be futile arguments and to refute forensic evidence and give Burgos Aviles false expectations. After yet another email where Pena admonished Martinez to follow his direction as lead counsel, Martinez responded to the defense team, "I'm not in the business of bending over for the DA. As soon as any bad evidence comes up, you are, I get it. You seem to be more interested in avoiding ineffective assistance of counsel and reversal errors than in winning the case for your client. I'm convinced that you have been practicing for 50 years and bending over for the DA for 50 years. These are the two attorneys arguing amongst each other. That's pretty bad. I suggest that they take you off before you send my client down the drain." So then, at an ex parte in chambers hearing, the court heard from both attorneys and Burgos Aviles. Pena repeated the complaints made in the motion, that Martinez created conflict between him and the client by giving Burgos false assessment of the evidence and telling the client that Pena had already decided that he's guilty. That's another thing you cannot do as the attorney. You can't do that. He said that Martinez does not agree with his strategy decisions, such as his focus on mitigating evidence or follow his direction of lead counsel. For his part, Martinez disputed Pena's accusations and questioned Pena's advocacy for his client. He said that Pena stopped investigating the case before discovery was completed, and that he was very concerned about the fact that Pena is the only one that defends people that are facing death penalty because he throws up his hands before discovery is fully developed. Now, that's a weird statement for one attorney to say about the other one. Burgos Aviles objected to the removal of Martinez, claiming that Pena did not communicate with him and was not preparing a defense. In that conclusion of the hearing, the trial court explained to Burgos Aviles that it believed that the ineffective working relationship between the attorneys would affect their ability to provide effective representation. Here's the situation, Mr. Burgos. You can also go get your own attorney instead of us paying for your attorney after you took the life of a little boy and his mother because you're a piece of shit. The problem between both counsels is very evident. The record is replete with that. I can't have that. He goes, I can't have that. I can't have that. You can't have that. The problem is that they can't work together. So it's not good for you. It's not good for your case. And it's up to me to make sure that these rights are protected. And the judge was correct in that. The trial court discharged Martinez and appointed William Boggs as second chair. Over the next year, Burgos Aviles filed 3 pro se motions asking that Pena be removed and Martinez be reinstated as his attorney. At a pretrial hearing, the trial court denied Burgos Aviles' motions. Wow, that's really stupid. Was he trying to get the death penalty? I think he was. Applicable law and standard of review. An indigent defendant is constitutionally entitled to appointed counsel, but not counsel of his or her own choice. So this is when he's fighting to get this other attorney put back on his case. So he's filing these motions, and these are the review of those motions. And there's the cite, the citing in the penal code for that. Nonetheless, once counsel has been validly appointed to represent an indigent defendant and the parties enter in an attorney-client relationship, it is no less inviolate that if any counsel is retained, and it cites another case, after appointment, the trial court cannot arbitrarily remove an attorney of record over the objections of the defendant and counsel. And it cites, here's the other citings. Holding that it was error discharged to appoint counsel on the grounds that he tried to interview a witness which was against the district attorney's rules, which is wow, he's really acting out, which is a tenuous and in actuality, it's a legal nullity. So in other words, had he actually done that, then they would not be able to call the person as a witness, which would have really messed up the case because that was a witness for the defense. This is not to say that the trial court can never discharge an appointed attorney over objections. It just cannot do so arbitrarily or without extraordinarily good cause. And there's his ex parte. Okay. The trial court's decision must be for some principled reason, not based on the trial judge's personal feelings and preferences. And then there's the next case that's cited. We review the trial court's rulings for an abuse of discretion. And it cited, Blanson versus blah, blah. The application. It was clear to the trial court, as it is to us, that the relationship between Pina and Martinez became so contentious that the representation of Burgos Aviles would suffer from it. The trial court stated that it could not allow both attorneys to continue representing Burgos because it did not want to try the case a second time, recognizing that the conflict between them could open the door to ineffective assistance of counsel. See, and you got to wonder, was Mr. Burgos Aviles the monster that he is? Did he realize that that's what he was causing right there, and that's why he continued on? Was he smart enough to try to create a situation where he had something for an appeal as soon as he was found guilty? That's what I'd like to know. I mean, is that what he thought he was doing? Burgos Aviles compared his case to McFarland and argued that if the trial court in this case was not allowed to remove the first-year attorney who slept during portions of the trial, the reasons for removing Martinez in this case was also not sufficient. In McFarland, however, the trial court did not remove the defendant's attorney of choice. It honored the defendant's wish to keep his retained attorney, but to ensure competent counsel, it also appointed a second chair. That is horrific. Imagine your first chair counsel is falling asleep during parts of the trial, so your secondary counsel is listening to everything and keep it up with everything, and you don't want to get rid of that person as part of your team? I would. That's crazy. That's crazy. Okay, so then it goes, the defendant challenged the competence of his chosen counsel. He claimed he had been denied counsel or, in the alternative, provided ineffective assistance of counsel. The Court of Criminal Appeals recognized that the decision to appoint a second chair was because the judge was caught between Silica and Charters. That's another case. In trying to ensure that both the competent representation and the defendant's right to counsel of his choice, the court was not, as in this case, reviewing an order removing counsel, and it did not hold that it would have been error for the trial court to make such a ruling. Here, where the relationship between Pina and Martinez appeared to be irreparable, there was extraordinarily good cause to remove one of the appointed attorneys. Faced with the choice of discharging Pina, the lead counsel, or Martinez, the second chair, the trial court chose to discharge Martinez. If Burgos Aviles had been charged with a crime that did not require the appointment of two attorneys who had to meet special qualifications, we may have agreed with him that the trial court, in having discharged one attorney, did not have the authority to decide which one. But in this case, discharging Pina would have left Burgos without a lead counsel until another attorney qualified for the death penalty case could be found, appointed, and had a chance to review all that happened to date. On this record, we hold that it was not an abuse of discretion for the trial court to discharge and replace Martinez. And I kind of agree with them right there. They don't want to drag this case out by having to get new attorneys, because this, that, and the other, and then you only have so long. You can't hold a case open for 4 or 5 years because of attorney problems like this. So I think they made the right choice. We overruled Burgos Aviles' first issue, so they denied that one. The second one, the trial court did not abuse its discretion by denying Burgos Aviles' motion to change the venue. Burgos Aviles argues the trial court abused its discretion by denying his request to change the venue of his trial to Bexar County. Motion to change the venue. Burgos Aviles filed a motion to change the venue, asserting that he could not receive a fair trial in Webb County due to inflammatory online discussions, significant media attention, and the notoriety of his case in both Webb and Zapata counties. He attributed this to the bias, the media environment in Laredo area. He further contended that the prejudice was compounded because his case was often discussed in the news in tandem with that of Juan David Ortiz, another Border Patrol agent who's charged and convicted of capital murder. See, now I'm going to have to go pull that case up and figure out what did he do. That's going to be interesting. On February the 23rd, a hearing on this motion, Burgos Aviles' only witness was Emily Shaw, with a decision analyst, which was commissioned to investigate whether the media coverage of Mr. Burgos Aviles had created a bias amongst potential jurors in Webb County. She reviewed a sample of 25 news articles and analyzed them for biased content. She reviewed online comments to news stories posted on social media and conducted a survey of 150 residents of Webb and Zapata counties and 150 residents of Bexar County, to the county to which Burgos Aviles requested his trial be held. According to the survey, 65% of respondents from Webb and Zapata counties had heard of the case and believed that Burgos was guilty, compared to 28% of the responding from Bexar County. In analyzing the media, Shaw also considered the comments on news articles posted on social media, which she says reveals bias and amplifies the media on which the comments were made. Well, that's an interesting study, isn't it? The state called Oscar Hale as a witness. Hale is a former chief investigator for District Attorney's Office, which was taking part in hundreds of jury selections, some of which were for high-profile cases. Hale testified that after the initial coverage of the murders, the media only covered the case when there was a hearing. Based on his experience with the juries, he believed the juries were always followed the judge's orders and came to a verdict in accordance with the law and the trial evidence. Not what they had heard on the news. Jamie Campos, a Laredo bar owner, also testified for the state that the news coverage of this case substantially slowed down after the initial reporting, and that the later news stories would usually only give a procedural update on the case after a hearing. He said that his patrons, when they talked about the murders, mainly discussed the fact that it happened nearby and did not express their beliefs about appellant's guilt. Finally, the state called Dr. Rick Morley as an expert witness on the statistical research methods. He testified that Shaw used faulty methodology. Okay, well, let's see what that's about. After the hearing, the trial court denied that motion as well. Applicable law and standards of review. The constitutional right to due process includes the right to change the venue when a defendant demonstrates his ability to obtain an impartial jury or a fair trial at a place of venue. And it has a bunch of sightings, which I'm not going to read. A defense charged with felony may file a motion for a change of venue under Texas Code of Criminal Procedures, and there's the number. The motion must be supported by the defendant's own affidavit that at least two credible individuals who reside in that county where the case is filed. He must show that there exists in the county where the prosecution is commenced so great a prejudice against him that he cannot obtain a fair and impartial trial. This can be done in a myriad of ways, including by offering newspaper accounts of the crime, video or television coverage, audio portions from the tape-recorded interviews or radio programs, witnesses from the community, or a result of results of the survey of the community sentiment by a pollster. So they did a poll about it. When, as in this case, the request for the change of venue is based on media coverage, the defendant must show that the publicity was pervasive. All right, let me take a break for a minute. That the publicity was pervasive, prejudicial, and inflammatory. Gonzalez versus the state, and there's the next citing. That widespread publicity does not by itself entitle a defendant to a change of venue. Sandoval versus the state, and there's that one. The defendant must show an actual identifiable prejudice attributable to pretrial publicity on the part of the community from which members of the jury will come. A trial court's ruling on a motion to change venue is reviewed for abuse of discretion and will be affirmed, and if it's within the zone of reasonable disagreement. And see, I don't believe that I believe that he actually did get a fair trial. He is upset because he's a narcissistic piece of shit, and he thought that if he could get this case moved to a different county, where he would be viewed differently. See, I think he was trying to play a card over there. Shaw admitted that she did not conduct an analysis specifically on the pervasiveness of the media coverage itself, one of the factors necessary to change a venue, and instead looked at the ethics of the potential coverage of the population. She believed that the evidence of the pervasiveness was that there was a high level of awareness and familiarity with the case. However, of the 25 articles that were reviewed by Shaw and were before the court, almost half of them were from April of 2018, the month of the murders. Okay. The remaining 14 articles published over the next almost 5 years before the hearing was sporadic. 5 years. Okay. I mean, they're not going to just change it and put it off and put it off and put it off. It had already been 5 years. That's what it says here. That's terrible. I didn't realize it had been that long. Damn. Okay, so was sporadic, and 6 of those were primarily about Ortiz. The other Border Patrol agent also charged with multiple murders and only referenced the appellant. Furthermore, some of the later articles that were about the appellant were short updates on the status. Appellant cases such as his request for a trial extension or gag order. He didn't want anybody talking about this. He wanted this extended. He was trying to drag this out as long as he could. And I guess he thought if nobody talked about it, everybody would forget about it and nobody would want to go watch this trial. You think he was embarrassed? Because I think he was embarrassed. I did. As for the comments on social media, Shaw testified that some examples from the there was 111 comments on an article posted on Facebook by Laredo Morning News. Only a part of the comments is included in the record, and not all are negative for Burgos Aviles. For example, the top comment states, to begin with, he is not guilty yet. Okay, he's being accused of the murders, but not proved yet. Aside from the pervasiveness factor, Burgos Aviles also did not show that the media was prejudicial or inflammatory. The other 2 required elements for a change of venue based on media coverage. News stories, be it from print, radio, or television, that are accurate and objective in their coverage are generally considered by the court not to be prejudicial or inflammatory. On appeal, Burgos Aviles does not argue that anything in the news was admitted was prejudicial or inflammatory. Instead, he points out to the inflammatory comments to news posted on social media. As discussed above, the record does not contain all the comments or describe the percentages that expressed opinions about his guilt. Based on this record, we hold that it is not an abuse or discretion for the trial court to find that the publicity was not so pervasive or inflammatory or prejudicial to warrant a change of venue. So they denied the change of venue request. On appeal, Burgos Aviles also contends that the number of jurors who had previously heard about this case, 14 out of the 15 seated jurors, is evidence that publicity was pervasive. Okay, and there's the citing. Stating that voir dire is one of the primary means of discerning whether publicity is pervasive. First, Burgos Aviles did not re-urge his motion at any time during the voir dire. And then there's the citing of it, noting that the motion to change the venue was not re-urged during the voir dire. So the motion to change the venue was overruled, and at pretrial hearings, it may be renounced by the state that the defendant during the voir dire examinations of the jury. But even if he had, the record does not show that the jurors were biased due to the media. The jurors that were seated were generally asked if they had heard about the case in the news or social media, but they were not asked if they formed an opinion on Burgos Aviles' guilt or stated that they would be able to reach a verdict based on the evidence. Okay. A defendant can ask for a change of venue when there is so great a prejudice against him that he cannot obtain a fair and impartial trial. The statute does not prescribe the publicity to be source of prejudice. Burgos Aviles argues that the trial court erred by completely disregarding the results of the survey, which he says is evidence of bias regardless of the reason for the bias. The evidence, though, was contested, so he contested it anyway. The state's expert witnesses on the stats testified that without a stated confidence interval, Survey results have no value because they cannot be generalized to the population. He also testified that the comparison of such survey results between Bexar County and Webb and Zapata counties is not useful because differing methodologies were used. They didn't all use the same testing in their study group to decide if it was or was not. The trial court, as a fact finder at this hearing, could credit the state's expert over the defense's. Okay, and there's the stating for that. The court is free to credit one expert over another or witnesses or any other witness over another. The trial court's denial on the motion to change the venue was within the zone of reasonable disagreement and not an abuse of discretion, and we overrule his second issue. So that's 2 issues out of I think it was 6 that he has. Number C, moving on to the next one. The trial court erred in admitting evidence of the baby's leg injury. However, the error was harmless. Burgos Aviles argues that the trial court erred in admitting evidence that the state argued showed that Burgos Aviles tried to harm the baby 15 days before he actually murdered the baby by injecting him with an unknown substance. Motion to preclude the extraneous offensive evidence. See, I think they should have been able to bring it in, period. It's an injury to that child that happened and when he was the only person in control of that baby, he was injured. They should be able to talk about it, in my mind, in my opinion. I'm not an attorney, I'm just a mom. So Burgos Aviles filed a motion to preclude the introduction of the evidence on the basis that state had not given him notice of its intent to use such evidence in accordance with the trial court scheduling under Rule 404B. Now, remember the Lori Vallow case? The case we just talked about the other day. That case had a 404B problem as well. A lot of them have 404B problems because you'll find that a lot of these people who actually end up taking the lives of other people have had prior run-ins with the law. They've done prior things. They have a little records of some sort. It's very rare to find somebody who's never done anything and then all of a sudden takes the life of somebody. That's rare, because usually when you've got criminal things happening, it starts out as small things and builds up to something big. That's usually how it goes. So, under the Texas Rule of Evidence 404, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with its character. And then there's the citing for it. Nonetheless, in criminal cases, such as evidence is admissible if it is for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of a mistake, or lack of accidents. To use evidence of uncharged conduct on timely request by a defendant in a criminal case, the prosecutor must provide reasonable notice before the trial that the prosecution intends to introduce such evidence, other than arising in the same transaction, in this case in chief. So, the dispute here is whether the evidence of the baby's injury arose in the same transaction as the murders. If it did, then the state was not required to give notice of the intent to present this evidence at trial. But we know it did not because it happened 15 days prior. After a pretrial hearing on Burgos Aviles' motion to trial court agreed with the state that the evidence of the incident on March 25th to the baby's injuries was in the same transactional context as evidence and could be admitted without prior notice. Okay, so that was a win for the trial court there. Preservation of errors. The state argues that Burgos Aviles did not preserve his complaint for appeal because the trial court ruled only that the notice was not required and that Burgos Aviles did not object to the admissibility when the evidence was introduced at trial. So in other words, his attorney should have said object, and they should have had the discussion up there at the front with the judge that was not heard by everybody, and he could have said, well, I'm going to contest that, or he's going to have a standing oh God, what's the word I want to use? A standing objection to that. And then they could have brought that back up in appeal. Okay. So he was not given notice and issues anyway, which turns on whether the trial court's characterizations of the evidence and assumes the transaction evidence is correct. Burgos Aviles' objections to lack of notice and ruling on the failure to give both sufficiently preserves and his complaint for the appeal. So applicable law and standards of review. The Court of Criminal Appeals has explained the difference between same transactions, contextual evidence, and other extraneous offenses and the evidence by its connection to the charged offense. Under Rule 404B, same transactions contextual evidence is admissible only to the extent that is necessary to the jury's understanding of the offense. It is admissible only when the offense would make little or no sense without also bringing in the same transaction evidence. That is, if it is admissible when several offenses are so intermixed or connected as to form a single, indivisible criminal transaction, such as that it's narrating this one, it is impracticable to avoid describing the other. So in other words, they're talking about, well, he's tried to hurt this baby before. He had problems. He didn't want this child. He never wanted to be responsible for this child. He basically had motive. He had motive. Okay, that's kind of what this is going with. And then there's the state argued that the evidence was contextual and part of the same transaction as the murders because it was necessary. It was necessary to explain the offense. You can't tell the story in this case without getting to how this happened, how they met on Facebook, how she got pregnant, how he was absent until the baby was a year and 8. So the baby was 18 months old. And then she files, asking for financial support and help. And then the first visit with the baby, he injures the baby. So he had intent. Yes. We disagree that the March 25th incident and the April 9th murders were not indivisible. They were separate incidences that could have been charged and tried separately. The jury could understand all the evidence supporting the murder charges without knowing about the alleged prior attempt to murder the baby. See, I just think they do go together, The state argues that under Rule 404B, the evidence would be admissible as evidence of motive, opportunity, intent, preparations, plan, and knowledge, as argued by the state in its brief. That may be true, but it is not the same transaction's contextual evidence. To introduce it for any admissible purpose, the state was required to give Burgos Aviles notice. Because evidence of the baby's injury on March 25th was not contextual, same transaction evidence, it was error for the trial court to rule that that notice was not required for the evidence to be admissible. Harm. Now they're saying, well, because he did this is the harm that it caused Mr. Aviles. Harm. Burgos Aviles asserts that the harm analysis that applies in the analysis used for this improper admission of evidence, citing, the state versus blah, there's the citing, the character of the alleged error and how it might be considered in connection with other evidence. Number 2, the nature of the evidence supporting the verdict. And number 3, the existence and degree of additional evidence and indicating guilt and whether the state emphasized the complained error. But when objections is the lack of notice, which was the basis for Burgos Aviles' motion to preclude this evidence, we look only at the harm that may have been caused by the lack of the notice and the effect of the lack of the notice had on the appellant's ability to mount an adequate defense. There is no adequate defense about poking a child with a needle and injecting him with something, right? There's no defense to that, period. Despite the lack of notice, Burgos Aviles was prepared to defend against the allegations. He presented Facebook messages that were evidence that the baby was sick before the meeting at Winfield Park on March 25th. Burgos Aviles has also presented medical records showing that he had been prescribed testosterone injections to explain why he had hypodermic needles in his possession. What did he inject that baby with? I want to know. What the hell? Because he injected him with something. We know he did. Finally, he was able to introduce evidence through cross-examination of the pediatrician and the medical examiner that the diagnosis after the baby's injury was that he was bitten by an insect. That was the initial, but that's not what the final. Because of the lack of notice and did not prevent Burgos Aviles from mounting a defense, it was harmless error to allow the evidence. We overrule his third issue. Whew, they should have, thank goodness. The trial court did not abuse its discretion in denying a mistrial. In his fourth issue, Burgos Aviles argues that the trial court erred in denying a mistrial after a witness's emotional statement and an outburst from the audience. This was very emotional. And if you watch this trial, if you remember this, I can remember this happening. And I was sitting in my living room just crying my ass off. I was like, this is unbelievable. He's sitting over there in that chair, just looking around like, oh, well, God, horrible. During the cross-examination of the border agent Francesco Lara, defense counsel asked him whether his initial statement that he gave to police was before he learned that Burgos Aviles was a suspect. Lara launched into an unobjectionable narrative about learning that Burgos Aviles was possibly the father of the dead child, during which he described his emotional reaction despite the trial court's attempts to stop his answer. And this is what was said during the hearing. The witness says, that's when everything just, I broke down is his word. Everything just, I felt like this weight on my shoulders and I started crying because I was there. I'm thinking, and the court says, wait for the next question, sir. The witness says, excuse me. And the defense counsel says, should we take a break, Your Honor? And the witness says, I'm good, sir. Here I am thinking we're supposed to be the good guys and he's supposed to be watching my back. And then he says something that they didn't understand. The court says, hold on, give me a second. And then the witness says, and I broke. I was heartbroken. And the witness started crying. The court says, give me a second, agent. Just go on a question and answer and basis, Mr. Boggs. The witness says, I'm good, sir. Thank you, Your Honor. Your Honor, I was just heartbroken. At that point, the trial court announced a recess and the defense moved for mistrial. The trial court denied the mistrial, but as soon as they returned instructions to the jury to disregard the emotional testimony. How can you disregard emotional testimony? That would be so hard. I mean, you're sitting there, you're watching this, you're hearing all of this, you're looking at that son of a bitch sitting over there in that chair, just smirking like he's going to get away with something, God. At that point, the court announced the recess, and then they came back. And here's what, but as soon as they returned, he instructed the jury to disregard the emotional testimony. I am now instructing you, this is the judge talking to the jury. I'm now instructing you that the opinion given by the witness with regard to who they are and what they stand for and whatnot will be disregarded by this jury. When the time comes to make a decision on this case, that you will not take into account or factor that any manner when making a decision on whether this defendant is guilty or not guilty of this crime that he is accused of, and then by the grand jury of the state. You are not allowed to weigh it, your considerations or mention it during your deliberations. The only thing is evidence that comes from here, not what comes from out there from the gallery. In other words, you can't think about how upset everybody was when you're making decisions. You will disregard any comments that you may hear, outbursts that you may hear as a result of that. You will not allow any of that to weigh in when you are evaluating whether or not the defendant is guilty or not guilty. I'm instructing you, in fact, to therefore not do so when the time comes. Thank you. So yes, the judge expects everybody just to forget those things. Now, they all agree that that's what they're going to do, but sometimes you gotta wonder, how in the world can you sit there and listen to that, knowing what he did, and not think about how emotional it was for that witness to tell the story? The trial court also advised the audience to refrain from comments to avoid the possibility of having a retry of this case. So, applicable law and standard of review. We review the denial of the mistrial for an abuse of discretion and will uphold the ruling so as long as it was within the zone of reasonable disagreement. And there's the statutes. Outbursts during trial, whether they are from witnesses or the audience, are not grounds for reversal unless the defendant shows a reasonable probability that the conduct interfered with the jury's verdict. And then there's, a statute right there. When reviewing the denial of a mistrial, we consider, number one, the prejudicial effect, and number two, the curative measures taken, and number three, the certainty of a conviction absent the prejudicial event. So, here's the case that they cited where this happened before. I'm not going to read all the sightings because we'd be here forever. So this has happened before, and it was decided that it did not affect it. Applications. Prejudicial effect. Burgos Aviles tries to distinguish this case from others in which the denial of a mistrial was upheld, arguing that Lara's comment, "We're supposed to be the good guys," was an inappropriate comment that Burgos Aviles was guilty. Burgos Aviles cites two cases in which one of the reasons given by the Court of Appeals in upholding the denial of a mistrial was that outburst was not a comment of guilt. Okay, and there's the citing. Holding that the trial court was not required to grant a mistrial when the victim's mother sobbed in the gallery because, among other reasons, the emotional outburst did not include an opinion. It was just an outburst regarding the defendant's guilt or his defensive claims. Okay. holding that a victim's widow's outcry during closing arguments was not prejudicial because it had no bearing on the murder or claim of self-defense. So that is the two cases that they were talking about that they cited as the reason why that it was these were hold harmless outbursts. Whether the statement is accusatory or indicates a belief in guilt may be a consideration, but it is not a determinative. Courts have many times held that a witness's outburst is not overly prejudicial, even when the witness clearly indicates that they believe the defendant is guilty. And there's some sightings. Let's go on to the next part. Okay, well, I'm not going to read the sightings because that might confuse you. So, upholding denials, blah, blah, blah. Well, I got to say it. Mr. Jimenez planned the murder. This is another outburst that happened in another case, and he's using these sightings as a reason to why he says these outbursts are basically hold harmless. Okay, so in addition, the trial court took immediate steps to cure whatever prejudice the testimony and outburst caused by instructing the jury to disregard Laura's and the audience's statements. We must assume that the jury followed those instructions. And then it goes, the trial court's instructions to the jury to disregard such outbursts are generally considered sufficient to cure the impropriety because it is presumed that the jury will follow those instructions. The state did not mention or try to capitalize on the outburst during the closing arguments. And that's true, they did not. Burgos Aviles also argues that the prejudice was incurable because the cumulative effect of Laura's statements together with the outburst from the audience. However, the very nature of the charges, the murder of a young mother and her baby, were very emotional and reasonable to assume that the jury understood that Griselda and the baby and their friends and family in the audience would be upset and emotionally listening to the evidence. Yeah, of course they would. Certainty of evidence. Finally, based on all the evidence linking Burgos Aviles to the murders, for example, his relationship with Griselda and the motive to keep it a secret, his plan to meet with her that day at the park, and the cell phones and GPS data showing that he had Griselda's phone after the murders, it's highly unlikely that the brief expressions of emotion by Laura and the audience on the occasions influenced the jury's verdict. No, it has nothing to do with it. I agree with him on that. Neither Laura's comments about his emotional reaction nor the audience's response created such an incurable prejudice that it interfered with the jury's verdict. We hold that the trial court did not abuse its discretion in denying the mistrial, and appellate's fourth issue is overturned. Boy, the trial court did not err in the following expert testimony on location data from the cell phones. In this final issue, Burgos Aviles argues that the trial court erred in allowing the state's expert witnesses to testify about the location of Burgos Aviles' and Griselda's phones based in part on the cell phone tower data. Motion to exclude the expert testimony. Prior to the trial, Burgos Aviles filed a motion to preclude the testimony of Andrew Masters, the state's expert witness, on cell phone site location data. In his motion, Burgos Aviles questioned the reliability of the underlying data to determine the exact rather than general location of Burgos Aviles and Griselda's phones, based on which the tower connected to the cell phones. You know, they talk about that particular situation in a lot of these trials as far as the general location, because it doesn't say it, you know, like this evidence is not, oh, it was, 10 miles over on the northwest corner of this coordinate, blah, blah. It's the generality of the location. You're in the general location of that tower, but it can't say, oh, you were 50 feet from it, exactly, that kind of thing. So this is argued a lot. This is a common argument in these trials. So it goes, location, okay, so it goes, he argued that cell towers can service a cell phone that is 20 or something more miles away, and that cell phones do not always connect to the closest tower for a variety of reasons, for other reasons. And that is true. They don't always connect to the closest one. During the trial, but out of the presence of the jury, the court conducted a hearing on Burgos Aviles' motion requiring the trial court in a criminal case permit a party to examine the expert outside the presence of the jury about the underlying facts and the data. Both Masters and Manfred Schneck, that's a funny name, both Masters and Manfred Schreck, that's really his name, the defense experts on cell site analysis testified that preliminary hearings, Masters, an FBI agent with a cellular analysis survey team, the CAS team, testified that for his analysis, he used a variety of sources. He used a call detail records which show which cell towers were used by which cell phone. the timing advances report for Burgos Aviles' phone, the surveillance video, the Google locations data, which itself consists of 3 types of data: cellular, Wi-Fi, and GPS reports from the Motorola radio in Burgos Aviles' Border Patrol truck. Boy, they had to look at a lot of different pieces of data. Masters explained that the timing advance report, also called the per call measurement data, or the PCMD, provides more accurate location data than the call detail records. A timing advance report does more than show which tower the phone is connected to. It determines the distance the phone was from the tower by calculating how long it took for the signal to travel from the tower to the cell phone and back to the tower. What results in a geographic area in the shape of an arc. Okay. And the location of the phone is on the line of the arc or slightly inside of it. So while call detail records place the phone anywhere within this sometimes large coverage area of the towers, timing advances reports narrow the location to a small arc within the coverage tower. So now I'm going to have to, after we get through reading this, we're going to go look at cell phone tower and the arc and how it bounces back. And that's very interesting to me. Now I've got to go investigate that part. Masters testified that he was able to determine a general location using the call detail records and the timing advance report. He then verified the accuracy of the location within the Google Wi-Fi and GPS location data, the Motorola GPS records, and surveillance videos confirming that Burgos Aviles was in the area shown in the cell phone records. Based on all those records, his opinion was that Burgos Aviles and Griselda's phones were at the crime scene at the time of the murders and then traveled to different locations in Laredo and then back to the murder scene. In other words, because they were in his truck when he went home and took a shower and then returned to work like nothing ever happened. Schneck and defense experts disagreed that the timing advance reports produced reliable evidence of the phone's location. In addition, providing that the data about the distance of the phones from the tower, a timing advance report also includes the latitude and longitude. Schneck testified that, oh, that's interesting. So Schneck testifies that by using the latitude and the longitude given in the timing advance report for Burgos Aviles' phone and the time that the phone was supposedly at each location, he found more than 5,000 errors and almost 7,000 improbabilities in the timing advance data. That seems to be way too large. That's way too large, in my opinion. Not that my opinion matters. Masters agreed that the latitude and longitude provided in the timing advance report is inaccurate and is only the network's best guess of a specific location of the phone along the arc determined by the data. Masters stated that in determining location, he does not use the latitude or longitude in the timing advances report and only uses the distance information, which is highly accurate, to determine the arc but the phone is actually in. That's pretty interesting. Now I've got to know what that means. I've got to go look it up. We got to look. Aside from the call detail records and the timing advance report, Schneck did not review any other source of information that Masters relied on. He stated, to the extent that there is other information available, I have no position on, and I don't know how. He goes, I don't know to what extent. This is Masters talking about his reading of the data. What he relied upon. Although he did not review the Google data, Schneck testified that it should not be relied upon because Google uses a proprietary algorithm and neither he nor anyone else can test its conclusions. At the same time, he stated that the source of the Google Wi-Fi information is on the Global Positioning Network, which is highly accurate. So applicable law and standards are reviewed. A qualified expert may testify in the form of an opinion or otherwise if the expert's scientific, technical, and other specialized knowledge will help the trier of fact to understand the evidence to determine the fact in an issue. The trial court acts as a gatekeeper, and before the expert is allowed to testify to a jury, the court must decide whether this expert is qualified and that the evidence is reliable and relevant. Boy, that's a mouthful. In determining whether scientific evidence is reliable, courts look at a variety of factors, which can include the following. Number one, the extent to which underlying scientific theory and technique are accepted as valid by the relevant scientific community, if such a community can be ascertained. The qualifications of the experts testifying, the existence of the literature supporting or rejecting the underlying scientific theory and the technique, the potential of the rate of error of the technique. Okay, hold on. the potential of the rate of error of the technique, and the availability of other experts to test and evaluate the technique, the clarity with which the underlying scientific theory and technique can be explained, and the experience and skill of the person who applied the techniques on the occasions in question. That is a mouthful to discuss. And then in Kelly versus State, however, these factors may not apply to expert testimony in fields based primarily upon experiences and training as opposed to scientific methods, which with the courts have labeled soft science. Remember, we also have a case where we talked about junk science, which is the shaken baby syndrome that is considered junk science. Is any of this considered junk science? I'm not sure. But it seems to me like you're talking about it as soft science as if it's maybe questionable. Not sure. We review the admission of expert testimony for an abuse of discretion. Okay. Here goes applications. Burgos Aviles challenges that the admissibility of the cellular location evidence on 3 grounds. He argues that the state failed to establish, number 1, the methodology used by Masters and Cass has been accepted by relevant by scientific communities. Number 2, that the methodology has been subject to testing and peer review. And number 3, that the underlying data used by Masters to draw the conclusion was reliable. I can see where they would question that. But it's used by courts all the time, accepting methodology. As recently recognized by the Tyler Court of Appeals, Texas courts have generally accepted the reliability of expert testimony about cell phone mapping, as well as maps created using cell phone geolocations. Okay. There's a bunch of sightings here on that particular part of this. I'm not going to read them all. Okay, look at all of that. Okay. And then it goes down to say, Nonetheless, Burgos Aviles argues that the methodology is not accepted because cell site analysis cannot be used to identify specific or exact locations and can only determine a general geographic area. However, he also recognized that courts admit such evidence where an expert makes clear that the mapping technology lacks the ability to pinpoint a definite, exact location. That's true. We've known that. Masters acknowledged that the limitation of the data from the cell detail records. In Rule 702 hearings, he stated that with only those records, he is constrained to say that the phone was somewhere within the footprint of this coverage area of a particular cell site, and that all he can conclude is that the cell phone is within the coverage area of the cell tower that was used. He also explained that the coverage area of the cell towers in Laredo can extend anywhere from 1.5 miles to 4 miles from each tower. Masters was also clear in his testimony to the jury that with cell tower data, he can only determine the general location of the device by which the cell tower and which the cell sector was used. And the phone communicating with a tower could be anywhere within the tower's coverage area. I know that's a lot to spit out. I know it's kind of confusing, but the maps he created had shaded areas to show those coverage areas. Although he testified that he could start pinpointing the phone's location, that was only when he used other sources of information, such as the timing advance reports, which is a separate report. Burgos Aviles does not challenge the methodology to the extent that it was used to show which tower the phone communicated with, nor does he challenge that the tower information narrows the phone's location to the coverage area of the tower. At its core, his argument is really that the information is not helpful. A similar argument was made in Thompson versus State. In that case, like here, the defendant argued that the analysis of the cell phone records to show location was not accepted methodology because it could not provide evidence of a precise location. And that is true. We know that's true. The court noted that the possibility that the defendant's mobile phone communications could have, in fact, originated miles away from the antennas does not necessarily render the cell phone related testimony unhelpful. It was helpful to the jury that the case because it showed that the defendant's mobile phone was active in the general vicinity of the murder scene and a location close to neither his home nor his employment, and that after the murders, the phones communicated with the antennas while traveling along the way to the vicinity of the defendant's residence. So as he was going home to take a shower and change clothes, the phone is pinging at each one of these towers along the way, just making a map of where all the phones had went. The same is true here because the information from all sources, including Google data, surveillance videos, and Motorola GPS data showed that Burgos Aviles' phone was at the park at the time of the murders, left the park afterwards and traveled to his home, and then returned back to the park. Although only the data from Griselda's phone were the call detail records, which could only narrow the phone's location down to the coverage area of the tower, not the exact tower, the information was nevertheless helpful to the jury. It showed that the jury that she was killed, her phone traveled after she was killed, that her phone had traveled outside of the coverage area of the towers, and in that area did so at the same time as Burgos's phone. So both phones were together and traveling after she was murdered. Therefore, while the call detail records could not confirm the exact location of her phone, they provided enough information to show that after the murder, the phones moved to different locations that was consistent with the movement of Avilia's phone. We hold that the methodology used by Masters was accepted, and that his testimony was clear, and that the information about what the towers and the phones used could not provide the exact location. So they admit that, but it's still not improper. Testing and peer reviews. Burgos Aviles also maintains that the trial court erred because the state failed to show that the mythology has been subject to testing and peer review. But, as discussed above, the admissibility of non-scientific expert evidence is held to a less rigorous standard than hard science testimony. And there's some, sightings in different cases where they've talked about this before. Cell phone mapping has been recognized as a soft science and a relatively simple task of mapping the general locations. Let's see, there's some more sightings. Hard science methods of validation, such as assessing the potential rate of error or subjecting a theory to peer review, may often be inappropriate for testing the reliability of fields of expertise outside the hard science. See, this is where you kind of get back into that junk science thing again. Furthermore, the data was tested. Although not the same sense that scientific data are tested, Masters conducted the drive test to personally determine the coverage areas of the towers, and he verified the cell site data with other sources: surveillance video, Google data, GPS data from the Motorola radio, and it explains that detectives use these other informations to independently corroborate the cell phone data. The use of other evidence in this case to independently corroborate the cell phone location data further supports the trial court's findings of reliability. The detective also indicated that he checked his results through other evidence he collected in the case, such as surveillance video and witness statements about where the appellant or one of the complaints were at a different time on the night of the murders. Okay, we hold that the scientific testing and peer review was not required for the cell phone evidence to be admissible. Reliability of underlying data. Burgos Aviles argues that the underlying data was unreliable because Sprint made disclaimers that it was unable to certify or testify the accuracy of the timing advance records, and that they were not created as a tool to identify customer locations. However, that same disclosure also recognizes that timing evidence records have been used to identify customers' locations, as it is a Sprint record that could possibly lead to the customer's location. Well, they do this all the time. Let's say a person is missing. Well, can you call a cell phone? Well, where did it ping at? And they go to this location area to go try to find the person. They're not going to be able to go to an exact X marks the spot, but they are they're able to go out to an area that's within a distance, like if you made a big imaginary circle of a distance from where this one tower is. So first, Masters agreed that some of the timing advance data, namely the latitude and longitude, are not accurate, as he testified that he does not use that part of the records. Second, as we have already said, he corroborated the data with other evidence of location. And third, he testified that the accuracy is verified because using similar records, the FBI has consistently and often found fugitives, victims, and missing people. That's true. For instance, he said that not a week goes by that we have not located a missing child from the same type of record. But more importantly, Burgos Aviles' complaints go to the weight of the evidence rather than its admissibility. The reliability of the underlying facts or the data turns on whether the data provides a sufficient basis to support the opinion. Boy, he's pulling at straws, I think. And whether there's sufficient basis is a quantitative rather than a qualitative analysis. The Texas Court of Criminal Appeals explains the difference between qualitative and quantitative by quoting a federal district court's opinion. The witness's testimony that he or she obtained a measurement of distance is sufficient to satisfy the facts and data, the element of Rule 702 for the component of the methodology. Whether the witness obtained the measurement with a precision laser, with a household yardstick, or by roughly pacing off the distance on foot is irrelevant to the Rule 702 analysis. Such a challenge bears on the quality, not the quantity, of the data obtained by the witness, and thus bears only upon the weight that should be afforded the witness' opinion at trial. Oh, that's a mouthful, isn't it? Here, Burgos Aviles does not argue that Masters did not have enough data from which to form his opinion. His argument is instead that the data does not provide specific enough information, that this is a qualitative challenge, and the example above goes to the weight, not the admissibility, of his opinion. Vigorous cross-examinations, presentations of contrary evidence, and careful instructions on the burden of proof are the traditional and appropriate means of attacking a shaky but admissible evidence. I don't think it's shaky evidence at all. It's used all the time. An expert's reliance on faulty information is a matter to be explored on cross-examination. It does not go to the admissibility. In cross-examination, Burgos Aviles did in fact question Masters about the Sprint disclaimer and the disclaimer that was admitted into evidence. The jury could consider Sprint's disclaimer to the accuracy of the data when weighing the evidence. We hold that the underlying data was reliable. The trial court did not abuse its discretion in following the testimony and evidence above the cell phone locations. We overruled Burgos Aviles' fifth issue. In conclusion, here we go. The judgment and conviction of Burgos Aviles is affirmed. Okay, and this was done on November the 25th, 2025. So there was his appeal, and his conviction has been affirmed. Now, will he appeal again? Most certainly he will, because he will go to a higher court. This was in, hang on a second, the Texas Supreme Court. You know, if you don't win your Supreme Court, if you don't win your appeal in your own state, then you go to the higher. You go to the Supreme Court outside of your state. So that's what's going to happen next in this case. It's pretty interesting, and I'm glad that they upheld his conviction there. So let's go back, and I am really interested now in the cell phone and the arcs that it was discussing. What time is it? We've been on. Let me see. Let me see if I can pull something up quickly about the arcing, because now I want to know, how does this play into this part? So let's go to YouTube, where they discussed the cell phone. YouTube. Okay, it was Burgos Aviles cell phone testimony. There we go. We'll pull this up right quick and see if we can find it. Oops. MONY. There we go. Let's see if I can find it real quick. Day 7, closing statements, verdict watch. Okay. Sentencing, jury hears jailhouse phone call. Oh, wait a minute. Let's listen to some jailhouse phone calls instead. Hang on a second. We'll come back to this case for other things just a second. So this is going to be, hang on. All right, hang on. Okay, so let me go ahead and share my screen over here so we can pull this back up. This is interesting right here. Here we go. All right, share our screen. And it's going to be jury hears jailhouse phone calls from Burgos Aviles. Here we go. And this is going to be full credit to, no, I'm not signing up, Court TV. Now listen, this is Court TV and it should be YouTube, but I'm not seeing YouTube. Let me go to YouTube. I have to do it for YouTube. If we don't do it for YouTube, then it's considered third-party information, and I don't want another strike on my damn. I don't want to strike on my channel. So we're gonna look up here. Okay, so jailhouse phone calls. Just a second. Okay. Burgos Aviles. I always want to spell his name wrong. Here we go. Well, you have to spell his last name correct if you want to pull it up correctly, right? Courtroom hears jailhouse phone call between Burgos and his wife. Now this is between his wife, and this is going to be part 1. And let's see, who is our full credit to? Hang on a second. This is Dirt and NAP now. Okay, hang on just a second, guys. Let me get this pulled up. Okay, I got to share my screen. Okay, this is part one. Okay. Oh, where's my screen share? Here we go. Share the screen. Share.
Other people, it's your problem.
Okay, and I'll deal with my problem.
So this is going to be Dirt NAP 81, full credit Dirt NAP 81. Okay.
So anything else you want to say?
No.
Are you
So that was just a little short phone call, but there's many parts to this phone call, so we'll just listen to them all for a minute.
So just little, I know.
That. Let me put my little screensaver over it so we don't get in trouble and get a copyright strike.
You're going to do it later?
Hang on.
No, I'm not going to.
Oops.
So that's my problem.
No, that's
Let me
not
find it.
I
No,
did.
where's my
This is all my feelings and my problem.
No, that's not what I said.
Okay.
I said
There we
little
go. All right, there's our dots. Let's protect ourselves from
other
copyrights.
people, it's your problem.
Okay, and I'll deal with my problems then.
Okay.
Just like I deal with
Hope you
all
can
the
hear
other
that. Okay.
problems.
This is wife number. This is call number one.
So anything else you want to say?
No.
Are you
Woo.
And then all of a sudden you just want to blow it on over. So
Let's
just
see how long this is.
I know.
No, I don't.
What?
No.
So what? So you're going to do it later?
No, I'm not going to. So that's my problem.
No, that's not like
No, I did. This is all my feelings.
Let's hear this.
and
I
my
think
problem.
let's hear
that's
number
not what I
two.
said.
That's my number two. I see number two. This is number two. All right, this is
You
part
got
four.
anything
Hang
you
on.
want to tell?
It's part one. Where's part two? Here's part three. Here's part two. Same phone call. This is the same phone call.
So yeah, tell me what's up?
Nothing bad. I was said I'll deal with it.
Okay.
Huh?
I told you I'll deal with my problem. Just like I deal with all my other problems.
Can you please not be like that? You know I don't have a lot of time to be like on the phone. You already know that, and you want to act like that.
Well, what do you expect, dude? You had a girlfriend. You're in prison.
Huh? Hello.
Yeah.
Tell me.
Well, how many other problems?
Damn.
So yeah, tell me what's up?
Nothing bad. I was said I'll deal with it.
Huh?
I told you I'll deal with my problem. Just like I deal with all my other problems.
Can you please not be like that? You know I don't have a lot of time to
Let's
be
go to
like
part
on
number
the phone.
three
You
now.
already know that, and you
That was
want to
number
act like
two. We'll go to part number three. If I can find part number three. Here's part number three.
that.
It's a short little 4-part call.
Hello.
Yeah.
So you gonna talk to me or no?
No, she's not going to talk to you.
No, I'll talk to you.
Hey, you know what?
What?
You complained before that I was calling you late. I try to call you at a certain time that I've been calling you for a while. You don't answer the phone.
Now we're going to go to
I'm
part
asking
number
for
4.
no reason. You just want me to, you want me to stop calling you? Is that what it is? Because I mean, it's going from 30 minutes, 20 minutes, now to 10 minutes. Before it got to be, don't call me at this time. Call me at this time. Now I'm calling you at this time. Now you can't answer the phone at this time. So what's the deal?
I'm not thinking of call me on.
I'm telling you right now. If you got some issue, just let me know.
I mean, you got to think. Well, what do you think? You think she's got some issues? Heck yeah, she's got some issues. You're sitting in prison because she had a girlfriend and a baby, and now she's lost her husband. Her kids have lost their the father of. Of course she's upset. I'd be upset too. Let's play this part.
Do you have
This is the
anything you want
last
to tell
final
me?
part of that call.
No, I don't want you to not call me. And you don't have to do it for 10 minutes anymore. I told you that.
No, but I'm going to because I know how responsible you are.
What?
But
What?
that's not what. Did you ever tell me?
Did he say, I know how irresponsible you are? Son of a oh, we gotta re-listen to that, because if that's what he said, I just want to jump through. Oh boy, unbelievable. Irresponsibility, right? Here we go.
Tell Jamie what's bugging?
How irresponsible I am?
What is bugging?
Look who's
he just said, I know how irresponsible you are. Look who is sitting in a jail cell awaiting trial for murder, and you want to talk about irresponsibility? That is a narcissist right there. Boy, what a piece of crap he is. Okay, let this finish playing, and then I'm gonna have to go for this afternoon. But here we go. God,
Talking, Ronald. Irresponsible I am?
What is speaking bothering you?
Nothing. You're nothing, Ronald.
All right, you have your chance. All right.
Okay.
Have a good night.
ooh,
Do you have anything you want to tell me?
No, I don't want you to not call me.
isn't
And you
that
don't have to do it
terrible?
for 10 minutes anymore. I told you that.
Responsibility.
But I'm going to because I know how responsible you are.
Mm.
But that's not what.
Let me get rid of some of these things. I know how irresponsible you are. I'm telling you what, if some man sitting in jail for murdering his girlfriend and a precious baby, and they were, well, let me just say this. If it was my spouse, we wouldn't be talking on the phone because we would be done. There'd be no conversation to be had. And number two, if he's over there calling me saying I'm irresponsible, I'd be like, who in the hell do you think you're talking to about who is irresponsible, right? Jesus, how terrible. Anyway, all right. So that is where this appeal case is so far. It's with the Texas Supreme Court. So the next move is it's going to go to the higher court next. We know it always does. And I'm going to keep tracking this case and see what is, just see what happens. And I want to make sure I want to know when he is officially over with all of his appeals and he can never get out of prison and then he can sit there and rot in prison where he belongs for the rest of his damn natural life. So glad to see everybody. Thank you for stopping by. We always appreciate you. We always appreciate you coming in to help support our channel. Um, we're kind of working at making it a little better, trying to find some interesting cases, trying to find things to talk about that other people are not talking about, maybe. So it's so good to see you guys. I'm going to get off of here now and go cook some dinner and get on with the rest of my day. I hope you all enjoy the rest of your day. Be careful out there. Take care of yourself. And like I always say, go hug your babies. Life is short and your time with them is even shorter. So I will come back tomorrow myself and probably Sprinkle will come on with me tomorrow. We'll talk about another case. But anyway, you guys go have a good evening. Thank you so much. Bye, guys. Oh, and if you get a chance, hit that button, that like button on the way in or the way out. I always forget to ask. Bye, guys.